Did the legislature intend within this law to create a carve-out to the common law principle?
But that's the debate that the courts are having. That's exactly the debate.
The Weekly Friedman, your source for the most essential information in the default industry. With your host, Adam Friedman.
Is the conversation on whether FAPA's created a carve-out of the common law principle, or is it literally, did the legislature mean to do away with the common law principle entirely?
In the context of FAPA, I don't necessarily think they intended to do away with it across other cases.
Is that even the question?
Specific to mortgage foreclosures.
No, but so is the question, did the legislature intend within this law to create a carve-out to the common law principle?
But that's the debate that the courts are having. That's exactly the debate. So there's language in FAPA. Section 10, the enactment clause, provides that FAPA shall apply in any action in which a judgment of foreclosure and sale has not been enforced. That contemplates a judgment being entered. Enforcement of a judgment is up for debate. There's several different decisions on what exactly that means. It doesn't explicitly say that a sale must be held. A different conversation for a different day. But it says a judgment of foreclosure and sale has not been enforced. Contemplating a judgment's entered, but it's silent as to whether there's an appeal from the judgment pending. It doesn't say when a judgment is final. And that's where the split is. It's the same language being interpreted differently by two different appellate panels. In Deutsche Bank versus Goldwasser, which came out first in early April, the Appellate Division Third Department interpreted that enactment clause and said, based on the legislature's statutory text that it shall apply in any action in which a judgment has not been enforced. They didn't put a limitation in about the judgment having to be final. Therefore, we're going to say that language was clear enough based on the absence of any limitation on timing. This can be applied anytime until a judgment of foreclosure and sale has not been enforced. And a judgment being final, as far as a right to appeal from it being expired, is a different concept from enforcing it. Because hypothetically speaking, judgment can be entered, notice of entry can be served, no appeal taken. That doesn't mean you enforced it. That just means the judgment's final. So in the third department, they said that was enough. However, in the first department, in U.S. Bank versus Gallant, takes a different position. That this FAPA enactment clause, FAPA 10, is different. FAPA 10 does not allow a defendant to bring up FAPA post-judgment. They say that the statutory text is not sufficiently clear, and that's the big difference. We have the exact same statutory text we're looking at, and we're interpreting it differently. We're saying this FAPA 10 is not sufficiently clear as to when the judgment of foreclosure and sale can be further challenged.
Let's say it's determined that the legislature intended to overrule or revoke the common law principle. What happens then?
That would resolve this issue.
How often does the legislature say, we're going to work around the common law principle that a judgment is final, and we're going to give a law that doesn't care about that common law principle? Is that common?
I would say it's uncommon. Generally, the assumption is that law is going to apply prospectively. And I think part of the reason that the plaintiffs' bar and the lenders are up in arms is because of the perceived harsh result of FAPA. That's where we get all these constitutional arguments and the notion that this is violating the takings clause because we have a judgment that's final and let's say it's been pending for several years. You're now going to pass a law how many ever years after the final judgment has been appealed and take away that property right?
It feels like this is an extreme exertion of power by one branch over another branch. Sure.
And that's one of the grounds for constitutional challenge is that it is punitive, that it's punishing a specific group of people and legislation is not supposed to do that, which is what I think you're suggesting.
There's a reason there are timelines. There's a reason there's a timeline to appeal.
Right. That is why there was this common law principle, is because there has to be an end to litigation.
Let's say it's determined this is the intention of the legislature. Allow retroactive laws to be applied well after judgments can even be challenged. So this isn't even retroactivity. This is like open up any case you want and do whatever you want. What if this was applied in a criminal context? Could that be feasible?
I'm not a criminal constitutional lawyer,
Sure.
but I could see why that creates some severe constitutional violations.
The lenders bar is saying this feels overly focused at mortgage lenders. That could be a valid concern.
Right.
What I'm just wondering, if the legislature starts overturning common law doctrines to specifically go after one group of entities, it feels like that has wide-ranging implications for any type of law that you want.
They would have to include similar language, like a similar enactment clause in amendments like you're contemplating. The FAPA-specific enactment clause would have to be taken, let's say verbatim or close to verbatim and apply if the Court of Appeals or the high appellate courts allow this type of language and this retroactive application, it could be a green light to the legislature to include language like that in other amendments going forward and then try to apply it in different contexts. FAPA's enactment clause only applies to FAPA amendments, but they could just simply lift that language and put it into other legislation going forward.
And Adam, to your point, the justification for the law was to correct what they perceived to be manipulation of the statute of limitations by the plaintiff's side. And then they proceeded to pass a series of laws that had nothing to do with statute of limitations and that had no implication on the borrowers. There was no prejudice to the borrower. CPLR 205A, the fact that the plaintiff has changed would preclude relying on CPLR 205. How has the borrower been prejudiced by that?
Okay, so I get what you guys are saying, that this would just apply to this law, so on and so forth, right? But it seems like this pops up and there's uncertainty because presumably the legislature does not often deviate from common law, right? But if they do here, right, if it's determined the legislature did intend to deviate in this instance, and this exact same language is used again, right now the departments are split and we're not sure how it's going to go. But it seems like if it was determined the legislature intended to overrule the common law here, the next time they use this language, it's pretty obvious. The legislature is seeking to overrule the common law and do whatever they want.
There's at least one or two pieces of legislation that have been introduced after FAPA, not necessarily in the foreclosure context, where very similar language to this was used. Not necessarily that the bills had passed, but there was legislation introduced that included similar enactment clauses to this.
And that's kind of where I'm going with this. I get how important this is for our industry, but is there a possibility the legislature is seeking to really just overrule common law in whatever direction they want?
Speculative. I can't obviously speak to that point, but it's possible that it's a test of sorts, seeing if this language could withstand challenges. And if the language can withstand court challenges, then they're obviously more free to use it in other contexts going forward.
One of the reasons the legislation was passed was to overrule a court of appeals decision that the legislature disagreed with. So, the law was expressly passed to overrule common law.
All right, so Zach, let's say this ends up going against the lender, right? We're saying now it's determined that FAPA can be applied retroactively post the time for enforcement of judgment or whatever it is, post-appeal. What happens? Where do we go from there?
Right, so if the Court of Appeals chimes in and says, this is how it is and you can apply it post-judgment, the scope of the challenge would probably be limited to constitutional ones. So hopefully the Court of Appeals entertains arguments regarding FAPA being a violation of the takings clause and other such, due process violations, et cetera.
Steve, where do these cases leave us in litigation?
Well, based on the First Department case law in Gallant, all the trial courts within the First Department must apply Gallant, according to which FAPA amendments cannot be utilized by a defendant to try to get a foreclosure dismissed after the time to appeal from a final judgment expired. So that's Bronx County and New York County. And as a general matter, the First Department precedent is binding on itself. That's a general concept subject to slight deviation from, but generally speaking, the First Department will continue to adhere to Gallant going forward. In the Third Department, by contrast, all the trial courts within the Third Department, a lower volume county with lower balance mortgages, the Third Department counties, as well as the Third Department itself, other panels, must allow for defendants to raise FAPA amendments to challenge foreclosures even after the time to appeal from a final judgment expired, up until a time a judgment of foreclosure and sale has been enforced. The enforcement being another term that will eventually be subject to litigation in the Third Department inevitably to figure out when the cutoff point is. Now, where does that leave the Second Department and the Fourth Department? Those courts, the trial courts and the appellate courts, are free to rule in any manner they like. Because there's a split. So generally speaking, if an appellate court has ruled on an issue, one appellate court, and the other three appellate courts have not ruled on the issue, all the trial courts are bound by the one appellate court ruling under the doctrine of stare decisis. In a situation where there's a split between the appellate courts, the trial courts have the latitude to rule in any manner that they agree with. So they can rule in accordance with Goldwasser, they can rule in accordance with Gallant. Hypothetically, they could rule in some sort of modified manner where they create their own sort of cutoff date, maybe something more express than we're seeing in either of these cases. Fourth Department case in Florida, Capital Notes versus Paul, you had mentioned initially that it seems like the Fourth Department could be leaning leaning towards where the first went. It's not explicit enough to definitively say that, but that's what the language of this case indicates. The Court of Appeals ultimately needs to get into this case to resolve these issues, or otherwise you could have the first and second department ruling in manner A, while the third and fourth departments, which sometimes will rule more in unison, could agree and give the defendants more flexibility, greater time periods to rely on the FAPA amendments. But right now, it's the trial courts can continue to do whatever they want, and really only the third department and the first department, those decisions are binding only on those department trial courts.
Guys, this is very interesting stuff. Thanks for joining Zach Gold, Steve Vargas, and I on the Weekly Friedman, your source for the most essential information in the default industry. Thanks for tuning in, and we'll see you next time.